multiple job locations. H1B roving employees require special attention and analysis. In general, if an employer sends an H1B worker to a new worksite not listed on the labor condition application, the employer must act to maintain compliance with the regulations. The DOL regulations attempt to address this situation, but in fact create a series of confusing rules. Place of employment. The regulations include a detailed definition of place of employment. This definition governs what an employer must do to maintain LCA compliance. The definition creates several exceptions that are not considered new places of employment, such as places where an H1B may travel temporarily for developmental activity or to receive training. If there is no new place of employment, then the employer's LCA obligations remain fixed at the home base. Let's take a look at a case here. Company A is an IT company that develops its own proprietary software and also provides consulting services for its own software and related software. The company sends its consulting employees to various client sites throughout the region. Placement will last anywhere from a few days to 1+ years. In all cases, Company A is the employer, maintaining all requirements of control over its employees. John has just moved from one client site to another to customize Company A's software program. It is estimated he will be there for at least a year. The LCA for John's H1B does not cover this new location. Company A will have to file a new LCA and may have to file an amended H1B petition. Bijou is a senior manager in the consulting section of the company. He has a permanent office at the company's headquarters, but spends much of his time on the road, visiting client sites and evaluating the work of Company A's employees. His LCA only covers the location of the company headquarters, but since he is a peripatetic employee, a traveling employee, and spends less than 5 days in any one location, a new LCA is not needed to cover his travels. Alicia works in the software development division of the company, but has just been sent to a client site for a short term, 30 to 45 days, to fix a bug in a module that she had primary responsibility in development. This is an initial launch of the module, and the company wants to get all the kinks worked out quickly. Because this is a short-term assignment, a new LCA is not required. Let's go back and look at the employer's obligations when H1B roving employees goes to a new place of employment. If the H1B roving employee is going to a new place of employment or worksite, then the employer must do one of the following. Repost if the new worksite is within the area of intended employment. In this case, the employer must repost the notice of the LCA at the new worksite before the H1B begins work there. They must use the short-term placement rules, or they have to file a new LCA for the new worksite. Let's look at some exceptions. There's always exceptions. The employer is not required to take one of the above 3 steps to maintain compliance in the case of that peripatetic workers and workers who travel occasionally on a short-term basis. That would have been Alicia and Bijou. The regulations define a new type of H1B employee whose work is peripatetic in nature and that the normal duties of the occupation require frequent travel. Peripatetic workers may travel constantly, but may not spend more than 5 days in any one place. For such peripatetic workers, a new location is not considered a new worksite, and therefore does not require a new LCA. Similarly, H1B workers who travel occasionally on a casual, short-term basis, not exceeding 10 days, to a new location are not considered to have a new worksite with new LCA requirements. Although in these cases the employer is not required to take one of the 3 steps above to maintain compliance, the employer is required to pay travel expenses for each day the H1B is traveling, both weekdays and weekends. Let's look at short-term placement rules. The short-term placement rules permit an H1B to travel up to 30 or 60 days per year to another place of employment. However, the employer may not use the short-term placement rules in any area of employment for which the employer has a certified LCA for the occupational classification. If the employer has such a certified LCA with an open slot, then the employer must use that and add a copy of the LCA to the employee's public access file. If the employer has a certified LCA but does not have any open slots, then the employer must file a new LCA. The regulations specifically prohibit employers from continuously rotating H1B employees to short-term placements in a manner that would defeat the stated purpose of these rules. The rules were designed to give employers flexibility and enough time to file a new LCA when necessary. Also note that the filing of a new LCA may still require the filing of an amended H petition due to material change in employment. If you think these rules are confusing, they are. It will take careful analysis to determine when a new LCA is required and if an amended H1B petition may be required. If you have any questions about the H1B roving employees and related employer's obligation, consult a Visa Pro immigration attorney. We will be happy to guide you through this process.